Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we will bring to you the judgment of the Supreme Court on disqualification of convicted members of state legislature and parliament. To discuss the issue, I have with me Major General Anil Verma, National Coordinator, Association for Democratic Reforms, and on the OB van, Dr. S.Y. Qureshi, former Chief Election Commissioner of India. Now for the headlines. The judgment takes away protection from disqualification of convicted members provided in the Representation of People's Act. Disqualification will be valid for a period of 6 years from the date of the member's conviction. Convicted members will be disqualified from their position, leading to immediate vacancy of their seat. The Supreme Court, in a recent judgment, has ruled that persons once convicted for 2 years or more will be disqualified even if they are members of the state legislature and parliament. Before this judgment, the people's representatives could continue to contest and be parliamentarians till their appeal against conviction was pending in appellate courts.
The Apex Court struck down the specific part of the Representation of People Act which provided protection from disqualification. Section 8, subsection 4 of the law gave parliamentarians and legislators 3 months' time for appeal. During these 3 months, if their appeal was pending in the court, they could continue as people's representatives despite being convicted.
Due to this obnoxious provision in Section 8, subsection 4 of the Representation of the People Act 1951, even murder convicts could continue as honorable MPs and MLAs and MLCs. So much so that in UP, we had an MLA who was convicted for murder of a former cabinet minister in the government. Then we had another MLA who continued as such despite his appeal against conviction having been dismissed.
Let's look at what the Representation of People's Act states about disqualification. The law states that any person seeking to contest elections for parliament or legislature will be disqualified if a person is convicted of any offence and sentenced to imprisonment for not less than 2 years. He will be disqualified from the date of conviction and will continue to be disqualified for the next 6 years after he is released. But the exception which the Supreme Court quashed said that this disqualification will not be effective for a person who on the date of conviction is a member of parliament or the legislature of a state. Such persons will get 3 months' time after conviction to appeal to a higher court. If within the period an appeal for revision is pending in the courts, he will not be disqualified until that application is disposed of by the court.
My concern was the Act, Section 8, permits convicts to continue membership. Members who are convicted to continue their membership despite the conviction given by courts. That too on very antisocial offences. Very much not private offences, public offences which affects the public as such. It is not an individual type of offence, but against the public system.
Supreme Court advocate Lily Thomas and NGO Lok Prahari filed a petition in the Supreme Court which led to immediate disqualification of the MPs in the Lok Sabha like Lalu Yadav, Rashid Masood and Jagdish Sharma. The petition has challenged the validity of the specific section which gave protection to sitting parliamentarians who had been convicted.
Experts believe that the Supreme Court verdict is a small step in cleaning the dirt in Indian politics. They are of the opinion that the government should not label this significant judgment as judicial overreach. With cameraman Ashwini Kumar, Dipali Pandit for Rajya Sabha Television.
A bench of Justice A.K. Patnaik and Justice S.H. Mukhopadhyay struck down the particular section of the Representation of People's Act that allowed lawmakers a 3-month period for filing appeal to the higher court with a motive to get a stay of the conviction and sentence. My question to you, sir, straight on the OB, sir, Mr. Qureshi. Sir, after the implementation of this judgment has been in implementation for a year and a half now, nearly, and several elections have held with this judgment in operation. Going on from here, sir, fast tracking of cases against politicians with criminal background, sir. Is there an issue that needs to be resolved on that front, sir?
Oh, yes. We have been pressing for the last 20-25 years for disqualifying candidates against whom criminal cases are pending. The reverse argument is that till convicted you are innocent, therefore you cannot be debarred from contesting. Our stand has been that forget these minor cases, but if the cases are of serious nature, heinous nature, rape, dacoity, murder, kidnapping, etc., and a court of law has framed the charges, at least at that stage some application of judicial mind has happened. At least after framing of the charges, these people should be disqualified from contesting. And of course, the opinion of the jurists and the court is divided on this. And they say that till convicted you are innocent. But the alternative route of fast tracking these judgments is still being considered, and I think that itself should be taken on a fast track.
So
fast track judgment probably is the best answer.
What do you think is the problem with fast tracking of cases and the threshold that you mentioned, charges being framed by the court? On these 2 points, sir, where is the problem? Is the government not ready? What is the fundamental reason for not allowing this argument to be converted into policy and then framed into law and then being implemented?
I think the onus is entirely on the judiciary, because even in the context of election petition, the law provides that election petition will be decided within 6 months. It is already the provision of law. But except for the High Court of Kerala, which has been deciding such cases within a year, no court has been deciding these cases for 4, 5 and even after 5 years. So it is entirely in the domain of the judiciary. But in a significant judgment again in 2013, Supreme Court had ordered that the cases should be taken on fast track, and every court should be asked to decide the case within a year. And if it is not able to decide such cases, they should report to the Chief Justice of the respective High Court, explaining the reason why it is not happening. I think that needs to be implemented in letter and spirit.
I'll get Major General Verma in. Major General, on the same point of fast tracking of cases, where do you think is the problem? Why is the judiciary not being able to push hard for it? Because that is what is going to change the entire political diaspora and cleaning of it. And that's very important. Where do you think is it getting stuck?
Okay. Amritanshu, before I come to that, I would like to give a few statistics. Firstly, as of now, 34% of our MPs have got criminal cases against them.
34%?
Yeah. Now, out of that, specifically those who are facing Section 8, subsection 1 and subsection 3, there are 11%, meaning to say about 57 MPs are facing charges specifically which can lead to disqualification.
Okay, under 8, section 1 and 2, which is essentially, if I can clear it for the viewers, section 1 says it lists out a certain number of laws which are really grave and serious, and the violation is, even if you get a fine, you are disqualified for 6 years. That's the section you're talking about.
Yeah, section 8.1 and 8.3. Under 8.2, none of the MPs are there, but under 8.1 and 8.3, and out of that there are 11 people in which out of 10, 8 are from BJP, which includes Uma Bharti, who is a minister.
Okay.
So the point which I am trying to say, and the average pendency as per our research is 8 to 10 years for these sections.
Okay.
8 to 10 years is the average pendency. And Dr. Qureshi already mentioned that in a separate Supreme Court judgment of 10th March 14, wherein it specified that all the MPs and MLAs who are facing charges under section 8, 1, 2, 3, their things should be fast tracked, within 1 year it should be done, and if not, you know, the state this thing. Now we have tried to find out as to what is the status of this. There is no information available if anything has happened at all. Now, in connection with this, I would like to highlight there is another case which Supreme Court in September 15 has issued notices to the union government and the state government of UP. And there is a amicus curiae who has been detailed, Mr. Luthra. Now, this is based on a Karan Singh versus State of UP case of 2006, in which the Allahabad High Court appointed a committee under Mr. Prakash Singh, who was a retired DG police of UP, and this committee had submitted 6 reports, and they were asked to, you know, go into the reasons as to why the political space is being usurped by the criminal elements, what is the modus operandi of these criminals, this thing, how what is the impact of the, you know, criminal people and what is their influences, this thing, and how can their entry be checked, how can we improve the investigation measures, how can the cases be fast tracked.
A lot of electoral reforms.
And lastly, how to prevent the withdrawal of cases which the state governments do against the politicians. Now this Prakash Singh committee gave 6 reports, and as is always what happens in our country, UP government did do nothing about it.
I'll get in Dr. Qureshi on that.
Yeah.
So, Dr. Qureshi, withdrawal of cases is another problem by the state. So, their complaints filed, FIRs are filed, they're taken to a certain level, and then suddenly the state government decides that the cases against these prominent politicians should be withdrawn, and the state withdraws the cases. This is rampant in state governments all across India. How do you check that from happening?
Of course, it's a very serious matter, and I remember one specific case in Karnataka when we had filed FIR against certain politicians, and after the election, the cabinet withdrew all the cases. So we went to a court which decided in our favor. Then state filed an appeal. I think the case is still going on in some court. Maybe it has reached the Supreme Court, but it has to be put down with a heavy hand for sure.
And so also these electoral reforms, so to say, to weed out criminals from the political system has been on for quite some time. It's nearly about 10 years or 15 years of my career. I have gone through several recommendations of the law ministry and of the election commission how to change and transform this. But nothing seemed to have actually taken effect on the ground, and it is only the judiciary, especially the Supreme Court, which is spearheading the entire effort. The legislature doesn't seem to be acting at all.
Yes, in fact, this is very interesting that most of the significant reforms, the electoral reforms, have come through the judiciary, through the Supreme Court, which is why I have often said that the Supreme Court has become a guardian angel of our democracy.
Correct, sir. But what happens to the legislature? Isn't there any responsibility on part of the legislature to bring in these changes? After all, we have a government which has gone on record when the campaign was on, saying that they would weed out politicians with criminal backgrounds. What has happened to all that, sir?
Yes, you are absolutely right. It is the responsibility of the legislature, and when they do not discharge their responsibility and the Supreme Court comes in, then you accuse Supreme Court of activism and overreach, which is not correct. Actually, legislature itself should understand its responsibility. And also, I would like to say that the reputation and the image of the politician in the public mind is very, very low, which I think is very dangerous for democracy. You know, because you can't love democracy and hate politicians. But who has lowered the image of the political class in the eyes of the people? This kind of conduct only. Therefore, it is for the political class itself to repair the damage and improve its reputation.
Now, I'll get Major General Verma in. Do you see any effort by the legislature to bring in these changes? This was one of the major issues during campaign of the present government, that they would weed out criminal elements from politics. They would clean the system. Nothing has happened.
See, my sense of the thing is that they pay lip service to this. They are not very serious about it. I can give you an example of the CIC full bench judgment of June 2013, where they declared that the 6 national political parties will come under the RTI, and nothing happened. So now ADR has filed a PIL in the Supreme Court. You see, unless there is internal democracy in the political parties, there is transparency in their dealings, there is a willingness to show reform, nothing can happen.
Okay. Time for us to head into a break. When we come back, we will talk about the vacancy of seat on disqualification of the members. Welcome back. The Supreme Court in its judgment said that once a person who was a member of either House of Parliament or House of the state legislature becomes disqualified, his seat automatically falls vacant. The court said what is a disqualification for contesting candidates will also be a disqualification for a member of the Parliament and state legislatures.
The Supreme Court removed 2 different parameters governing disqualification of contesting candidates for MPs and MLAs and sitting MPs and MLAs. The Supreme Court clearly explained that an order of stay does not mean that the conviction is non-existent, but it means that conviction is temporarily non-operative.
They exempted the sitting members of the Parliament and the state legislatures who were convicted prior to the judgment and had filed an appeal taking advantage of Section 8(4) of the Act. Now on this, we had filed a modification application also in the Supreme Court to include them also, but somehow that was not accepted.
The existing law has 3 categories of disqualification. In the first category, offences like promoting enmity between different groups on the grounds of religion, offence of bribery, offences relating to rape, offence of cruelty towards a woman, promoting untouchability, offence of committing terrorist acts and insulting the Indian national flag or the Constitution, only a fine can incur disqualification for 6 years. If the conviction is of imprisonment, then the person will be disqualified for 6 more years after completion of imprisonment. The second category is a person convicted for the violation of any law providing for the prevention of hoarding or profiteering, any law relating to adulteration of food or drugs, any provision of the dowry prohibition law and sentenced to imprisonment for not less than 6 months shall be disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years since his release. The third category is of a person convicted of any offence and sentenced to imprisonment for not less than 2 years will be disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years since his release.
We were satisfied because the Supreme Court judgment struck down Section 8(4) of the Representation of People Act. It said that that subsection was not valid, and henceforth even a sitting MP or MLA, when they are convicted of a criminal case with 2 years of imprisonment, would be disqualified immediately, and they would have to vacate their Parliament or State Assembly seat. And 3 people have already had to do that, including Lalu Prasad Yadav. And therefore, the judgment has had an effect. It has had the desired effect. And now political parties are also becoming a little careful in giving tickets to people whose cases may be decided during the life of that Parliament or State Assembly.
The UPA government had attempted to overturn this judgment by bringing in an amendment known as the Representation of People's Second Amendment Bill 2013. But the Congress party led by its Vice President Rahul Gandhi had objected to it. The amendment was never considered after the objection.
The bench observed that it was unconstitutional to, on one hand, disqualify convicted members from contesting election, and on the other hand, allowing them to continue to be Member of Parliament and Member of Legislative Assembly. Therefore, they struck down the provision that protected the members from disqualification of their membership. With cameraman Ashwini Kumar, Dipali Pandit for Rajya Sabha Television.
The verdict is believed to be a step to clean up the system by closing the escape route for convicted MPs and MLAs. So very quickly, sir, the question about how to clean the system of criminal elements in the political system. Sir, there are three parts to the disqualification, which is part of the Representation of People's Act. There is 181, the first part is where even a fine incurred on violation of certain laws will debar the politician for 6 years. Then there is a second category which even if you get 6 months imprisonment under those laws, then you will be debarred. The third is 2 years under any law. So the third one is known to most of the people in this country. Well, why hasn't the first and two categories, the first category and the second categories, advertised enough? Because if that is advertised enough, I'm sure there will be a lot of cases against them and the criminal elements will automatically be weeded out. Your
see, if I may give you details, like I was mentioning, there are 10 MPs presently who have charges which have been framed under section 8.1 and 8.3. And I mean, there are people, you know, like Pappu Yadav and all, who got 13 cases against them. So you can imagine this thing. But the issue is that people are charged under 8.1 and 8.3. Somehow in the current list, there is nobody who has been charged under 8.2.
correct.
Yeah.
So that means there is not enough awareness about 8.1 and 2 only for filing, contesting or candidates. They know the relevant operative portions of 8.1 and 2, but it is implementation wise, it's very weak. Dr. Qureshi, can you hear me?
Yes, I can. And I entirely agree with you that the 8.1 and 8.2.
Yes, sir.
8.1 and 8.2 are not widely known. General perception is that after conviction, only the conviction of more than 5 years, people are disqualified. But you are right, in some cases, even 1 day's conviction is enough for disqualification. So on conviction, there is surely disqualification. But our stand has been that even before conviction, during pendency of the case, at least in the cases of very serious offences, heinous offences, there should be the bar. And it is not just Election Commission's view. Even the Law Commission, as recently as last year, which consists of only jurists, and has recommended that they should be disqualified from contesting when the case is going on and on.
So my question is that the Election Commission has huge resources to advertise, especially the first and two categories. The first category, only a fine can disqualify a politician or an aspiring politician for 6 years, just a fine under several laws. And the second category is 6 months imprisonment. That we already have in place. Why isn't being advertised, or most of the people don't even know of these two parts that exist? The Election Commission can surely at least advertise that.
Well, this is not a question for advertisement as such, but it should be in public knowledge and public debate, and it's more a question of law. If somebody has to be disqualified, the law has to come into the picture, whether people know it or they don't. The law knows it, and the enforcers know it, and it should come into play immediately.
Moving on, my
But
colleague.
I agree with you that there should be more public knowledge and there should be more debate, yes.
Moving on, my colleague Dipali Pandit spoke to Mr. Soli Sorabji, former Attorney General of India, and tried to get his point of view.
It has been quite some time after the judgment. Are you satisfied with the implementation part?
No, I'm afraid not. It has not been implemented as it should be. State governments are coming out with all kinds of legal excuses and pretexts to delay the implementation of the judgment. But I think now there should be a concerted effort in the Supreme Court to ensure that the judgment is complied with. Otherwise, it's just sound and fury signifying nothing.
Sir, do you think the verdict removes discrimination between an ordinary citizen and an elected lawmaker?
Well, not discrimination, but makes them all on the same footing. To that extent, yes.
Thank you, sir, for joining us on this discussion. Thank you, Dr. Qureshi. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.